maybe I'll just start with the session and students can join in. So in our previous session before lunch, we discussed the concept of liberty and individual choice with a focus on the right to marry. In this session, we will look at another dimension of liberty, choice, and autonomy. We thought we'll focus on reproduction rights, using abortion laws and regulation as a sort of peg to exploring this concept. So I'll just take you through the outline for this session. So just similar to the previous session, it's divided into two parts. In the first part, I'm going to take you just through the legal framework on abortion regulation in US and India. And then we will have a small discussion. This will be followed by Kalyani taking us through two cases which discuss the concept of reproductive rights and personal autonomy. And we will have an activity that follows from there. So it's a rather small session. It's just, I think we can just get right to it. So, we discussed the legal provisions in the previous session. So I'm just reiterating constitutional provisions for clarity. So in the Fifth Amendment, the Liberty Clause starts with no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of grand jury, except in cases arising in the land or naval forces or in the militia, when in the actual service in time of the war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. It's the last bit that's relevant. Then we will look at the 14th Amendment. I'm only going to probably highlight the most relevant bit. No state shall make or enforce any law which shall deprive any person of life, liberty, or property without due process of law. So this is the due process clause in the 14th Amendment. And then we will look at Article 21 in the Indian Constitution, which talks about protection of life and personal liberty. It states that no person shall be deprived of his life or personal liberty except according to procedure established by law. So now what I will do is I will take you through an overview of the legal framework on abortion in USA, as a lot of us may not be aware. As Kalyani will take us through this case called the Roe versus Wade case before the US Supreme Court. It struck down a very wide law that criminalized all forms of abortion in Texas, except in cases of medical emergency. So based on this judgment and the rationale Kalyani will discuss in the second half of the presentation, states have formulated regulations limiting or prescribing when and how abortion can take place. So Guttmacher Institute is actually an institute in the US that works a lot on reproductive rights. And they have an overview of the abortion laws state-wise, which is what was given to you as reading material. Some of these laws in the state are in effect, but are not always enforced. So, the major provisions or regulations can be categorized into some of the following categories that they have used, the Guttmacher Institute has used. First is the requirement of having a physician or having licensed hospitals performing abortion. So about 37 states in the US require abortion to be performed only by a licensed physician, and around 19 states require that the abortion can be performed only in a hospital after a certain point in time in the gestational period. And 17 states require the involvement of a second physician after a certain time in the pregnancy period. The second sort of limitation or regulation comes with gestational limits. Similar to the Indian landscape, and which we will see in the next slide, 43 states prohibit abortions after a certain point with exceptions. And these exceptions are usually to protect the life and health of the mother. And the third point is public funding. About 33 states prohibit the use of state funds for abortion, except for day in cases of rape. The state of South Dakota only gives funds for abortions arising out of life endangerment. The sort of fourth criteria we see is refusal. 45 states permit individual healthcare providers to refuse to participate in abortion. 42 permit institutions to refuse to perform abortions. And 16 of these states permit refusal only to private and religious institutions. The fifth criteria that the Guttmacher Institute looks at is state-mandated counseling and waiting periods. About 18 states require the mother to undergo compulsory counseling prior to performing an abortion. And 25 states, in fact, require for the mother to visit these, either the physician or the hospital, as the case may be, for a second time after a waiting period of having taken the decision to perform an abortion. So C and D points, if you see, that is public funding and refusal, are important because they don't per se prohibit abortion, but they decrease access to safe abortions. So this is the broad legal framework in the US. With these points in mind, let's now look at the Indian landscape. So in the Indian landscape, I actually extracted a piece from Sabrina Magal's article, The Right to Privacy and Access to Abortion in a Post-Puttaswamy World. I've just extracted the bits where she's talking about the legal framework. So the IPC prohibits or sort of states that the causing of miscarriage is a criminal offense. Both causing and accessing abortion would be a crime under this provision. The restrictions actually led to many women obtaining illegal and unsafe abortions. So in a response to this, a committee was constituted in the 1960s. The report of the committee was actually the report was to study the question of legislation of abortion, 1966. It's also known as the Shantilal Shah Committee. And this committee recommended decriminalizing abortion in certain circumstances. This is what led to the enactment of the Medical Termination of Pregnancy Act, 1971. Now, the MTPA Act does not give women the right to abort, but it merely lists certain exceptions when abortion can be performed without inviting criminal sanction. So some of the key features of this act, if you have to see, is one, originally, I'm talking about prior to the amendments, in 1971, it originally permitted abortion up to 20 weeks in the gestational period if there is a risk to life, if there are fetal abnormalities, if there's an injury to physical and mental health of the mother. Now, injury to mental health also includes pregnancy arising out of rape or failure of contraception. And sort of another circumstance judiciary has looked in when they consider mental health or physical health of the mother is to look at the actual and reasonable foreseeable environment. That is to look at the socio-economic conditions of the mother when determining whether the pregnancy should be terminated or not. And there is no limit on gestational period if there is an immediate danger to the life of the mother. The second requirement, similar to the US, is the requirement of having a physician. And only certain hospitals that are approved or licensed by the government to perform abortions can perform abortions under the MTPA Act. Subsequent to this, there was the 2002 amendment that was brought in. Under the 2002 amendment, abortion medication was permitted. And just before I move to the 2020 amendment, an important point that injury to mental health that I mentioned that includes failure of contraception, this was only permitted as a ground for abortion for married couples and not unmarried couples. The 2002 amendment did nothing to change that. It was actually finally, after a lot of public mobilization, that the 2020 amendment sort of addresses that issue. So the 2020 amendment to the MTPA brings in a few provisions. I'll just highlight some of them. First is it increases the upper gestation limit from 20 to 24 weeks for the special categories of abortion, including for survivors of rape, victims of incest, and other vulnerable women. These include differently abled women, minors, and others. And the opinion of one physician is needed for the termination of pregnancy up to 20 weeks of gestation. And you require the opinion of 2 providers for the termination of pregnancy from 20 to 24 weeks of the gestation. Now, this upper gestation limit will not apply in cases where the substantial fetal abnormalities are diagnosed by the medical board. There's also a confidentiality clause that has been introduced where it says the name and other particulars of a woman whose pregnancy has been terminated cannot be revealed except to a person who's authorized by the law. And it also extends medical termination of pregnancy services under the failure of contraception clause to unmarried women to provide access to safe abortion based on women's choice, irrespective of marital status. So this is the broad legal framework on abortion in India. So with these two in mind, and some of the questions that we did discuss in the previous session on individual choice and personal autonomy, I think it would be nice to now open the floor to discussion to understand, it's the next slide which has the question. Yeah, to understand how the legal frameworks in US and India view abortion. And over here, you can maybe first let's see what you feel, and then maybe I will try to steer the discussion on some of the points that we can address. One way to think about it is to see, okay, let's look at who's the decision-making authority, in fact, or when it comes to abortion rights and autonomy in the case of US and India. So clearly we see there's a difference in even the way the laws are designed. It's at the state level in USA as opposed to a national level in India. So any comments on that?
Ma'am,
Sure.
if you look at the Indian structure regarding abortion, it's more in a negative connotation. The whole life, it does not explicitly recognize a right to abort in a particular statute, or for that matter in the Constitution itself. Rather, it provides for certain exceptional circumstances, and then goes on to say that then there will be this committee headed by the government physician, etc. And when they permit, then you can do so. Whereas if we look in the United States, and there that has been one of the most contentious legal issues ever, that post Roe and Casey, that they've established the right to abort in the due process clause. So they've guaranteed a constitutional right in a positive manner. And then they've said that the states have to recognize this, and they do not. So it's more a person-centric thing rather than going to seek permission from a doctor or from a committee of sorts in a government hospital and then abort. So that is one of the major differences.
Thank you, Prithviraj, for that. So I think what he's trying to sort of the justification for regulation of abortion itself in the two jurisdictions is very different, or sort of the rationale. Over here, clearly it's a crime. And then there are exceptions where you can perform it, which is the sort of negative connotation that Prithviraj was talking about. And in the US, it seems like there is a right, but that right can be regulated in cases of compelling state interest, which is then enumerated in the various state level statutes.
Ma'am, may I ask a question?
Of course, go ahead.
Yeah, so the issue of abortion in US is highly politicized. So like, if you look at it, like the Republicans generally sway towards pro-life, whereas the Democrats usually sway towards pro-choice. So largely in the US, like abortion in itself is largely driven by a religious interest. So like generally your Jews and evangelical Christians are highly against it. So however, like the more progressive community, maybe even the Christians as well, they may look at it and be okay with it and say like pro-choice. But in US, there's like a clear distinction where like one group doesn't believe in it, whereas another does. In India, however, it's like a blanket term where like everybody, I mean, at least from the government side, everybody sees abortion as like a sin or like something which is a very big crime. So is there like a cultural thing behind it, or like why is it that India chose to approach the topic of abortion in such a manner?
I don't want to say too much. Maybe the students can sort of also respond to your question. But one thing that I just wanted to highlight is this criminalization of abortion comes from the Indian Penal Code, which was enacted during the British time, right? So this is the sort of Victorian morale that we continue to see, that sort of continue to carry on even post independence in India, which applies to a lot of the criminal provisions or penal provisions that we see. It could be in provisions of adultery, which was recently struck down by the Supreme Court, or even 377, which was also recently struck down by the Supreme Court. Hopefully we do, maybe if questioned, we can see the criminalization of abortion also being struck down by the Supreme Court if challenged. But with that background in mind, do any of the students want to comment on the sort of cultural differences when it comes to perceiving ideas of abortion and decisional autonomy?
Maybe while you can think about that, I'll just read out another comment by Arsha on the topic. So Arsha says that she thinks that the Indian legal framework does not view abortion rights as a choice, and it merely looks to prevent medical issues. The US legal framework acknowledges reproductive rights in a far more accepted form. The only issue that arises is that given the way decision making is carried out in India, we are left with a nationalized decision across the board, wherein in the US, it really depends on the state and how conservative or open they are with this reproductive right. I think that's also interesting because she highlights how the decision making powers in one country is actually with the state, while the other, it completely depends on the state, while the other, which is in India, it is a national decision of sorts.
Thank you. But adding to the sort of cultural point that Adrian discussed, maybe another thing we should think about is in both cases, do you think agency is given to the woman to decide, to keep, does the autonomy in both cases lie with the woman to decide whether she should carry out an abortion or not? That's another thing to think about. Yeah, Aditi, please go ahead.
Ma'am, regarding the agency point, that is whether autonomy is given to the women, from the Indian perspective, I think when it comes to abortion, the women is more likely to be seen as the victim here, rather than someone who needs to be rescued, so to speak. So I think there's a lack of agency in this regard. When it comes to the US overall, and also after the landmark judgments there, I think there was a more sense of agency, more sense of autonomy given to the rights of the women in terms of abortion. But having said that, we recently even saw the Texas abortion law. So, I mean, that was like 60 steps back from what they had achieved earlier. So it highly depends, when we talk about the US, it highly depends on which state are we talking about and which party, whether it's the Republic or Democrats who are there, depends more on that rather than the culture, is what I believe.
Thank you, Aditi.
Ma'am, just to supplement her point.
Yeah, sure, Prithviraj, go ahead.
And to add to Adrian's question regarding the difference and the cultural point thereof, I believe that to the best of my knowledge, abortion in India has never been such a big UN cry religious, or for that matter, such a contentious legal issue in terms of constitutional law, as much as it has been in the United States since ages. So that is the one stark difference between the two. And as we have inherited the penal code from the British of the 1860 era, the Indian government has just taken that and has reformed from that point. So that has been our starting point, that it is criminalized. And then we framed these laws in 1970, and then different reform committees. So the lack of contentiousness and a religious issue and the starting point, both are different in both these jurisdictions. And whereas if you look in US, and Aditi talked about Texas SB 8 and what the conservative legal movement and the Republicans want, they want Roe and Casey to be overruled. They explicitly want that, and President Trump has vetted and appointed judges in the federal and the US Supreme Court through that one perspective, one of the main yardsticks. So it is so much contentious that even the judicial appointments in the United States is done through the opinions of the abortion, or whether it is a right under the Constitution or not. So that is a very stark difference between the two jurisdictions, I believe.
Thank you, Prithviraj, for that. I think we have one comment from Ghanvi. She says, I think the negative connotation attached to abortion in India could also be a consequence of how widespread the menace of female feticide was years ago. Anyone care to comment on that? The fact that sex-selective abortions, carried on for a very long time, which is now prohibited, that you cannot terminate pregnancy on account of just identifying the sex. So any comments on that?
To a certain extent, I do agree with that point, in terms of, because female feticide was practiced at such an extent, and that the practice of before a child is born in the US, you can know the gender, and they even do the gender reveal party. But in India, we can't afford, culturally we couldn't have afford to do something like that. So having a law for, like, the way law for abortion is framed, to a certain extent stems from that as well.
So how would you justify, this is open for everyone to think, restrictions on decisional autonomy or on the personal choice of a woman by restricting her right to abort the child based on, say, gender or even any other factor that she would consider necessary?
Pratibha has a hand raised.
Oh yeah, Pratibha, please go ahead.
I'm not sure, but I feel that we should keep both of these things in a different position, because even if you look at female feticide, when gender is known, then also it is not something which a woman is doing by her own choice. As we stated, because of the structure of Indian society, there is some amount of pressure which is exerted on a woman to go for abortions when they get to know if she is having a female child. So I feel that is something which is a social problem, and that should be solved, but it should not be solved by infringing or by limiting the autonomy of a woman in general to abort. So the right to abortion should be present, and it should be differentiated from this aspect. And I feel some other ways, as we have now, like you can't even do the sex determination test, should be introduced rather than infringing or curtailing anyone's autonomy just to cure that thing.
Thank you so much for that, Pratibha. Anybody else? Are there constitutional solutions to this? Can we think of something within Article 21 itself that permits regulation? Or it could be the 14th Amendment in the other case, so in the US.
May I?
Yeah, please go ahead, Ravi. Yeah, go ahead.
Yes, yes, ma'am. Ma'am, with respect to US Constitution, I think Roe versus Wade very clearly in the ratio of 7:2, they gave a very clear judgment. With respect to the US Constitution, they specifically said it is a zone of privacy when it comes to getting pregnant or getting aborted. But they also held that the validity of the statute that basically gives this gestation period beyond the third semester, you cannot go for a pregnancy. They validated with the fact that it is only for the prevention of the actual human life that is existing. That is the mother. And they have also recognized that the unborn child is no longer a person. So it actually gives a constitutional backup also. The Roe versus Wade actually gives a constitutional backup to this legislation that provides for the medical termination of pregnancy in US. So that is what I have had.
Thank you so much for that, Ravi. Actually, we'll be adding on to that point in the second half of the presentation. Kalyani will take us through in detail through the Roe versus Wade case. So that's actually interesting that you brought that up. Anyone else want to add something, respond to what Ravi Shankar has said?
I have one point from the Indian perspective. So if you look at Article 21, it talks about right to life. So when generally abortion laws come in, we have this debate that a female has right to life, which includes the right to abort as well. Per contra, we have like the unborn child also has the right to be born. So basically, like both of them are having rights. So I don't know how do we actually sort of manage these two conflicting rights, because she has the right to abort and the child has right to come on the earth.
Thank you for that, Pratibha. In fact, that's actually tied into the larger religious arguments that they bring in the US context as well, when they're talking about the life of the fetus itself and protecting the life of the fetus. I think someone wanted to say something.
Yeah. Yes, ma'am, just to add one point, what she said. So when the US courts were hearing this, one of the argument that was canvassed against this was that the unborn child in the US legal system does not per se have a recognized right emanating from any of these statutes for that matter. But if we look at the Indian legal system or our personal laws, as well as the contract and transfer of property and other legislations, then in some special scenarios, the unborn child's rights have been recognized by the statute and even our courts in some cases. So that is one niche point, which point of differentiation between the two jurisdictions, which is significant in this debate of that right of the unborn child.
Thank you so much for that, Prithviraj. That's actually a very good point, that we do take into account the rights of an unborn child when we can enter into contracts on their behalf, we can transfer properties in their name. So thank you for that.
Ma'am?
Yes, please go ahead, Sunita.
Previous point, I think that the mother is having the fundamental right, but on the other hand, when we focus upon the unborn children's right, it is a statutory right. So on the basis of the presumption, we can't say it is an absolute per se. So it can be changed. So I think here the fundamental right of the mother prevails. So it is, woman is a sovereign over on her own body. So whatever she wanted to do is can do. Once the child can get, but she get inherited and fundamental rights from the constitution. So I think here the mother's right prevails over the kid.
Thank you so much for that, Sweta. That's also a very useful point to keep in mind also when we carry forward with our discussion and future, the next activity that comes in. I think if any of you have any further comments, please put them in the chat box and we'll try to respond to them during the remaining session. So Kalyani, then I will hand it over to you to take forward the second part of it.
Thank you. So now that we've sort of seen the provisions and the history of how the provisions have developed in both the legal frameworks, we will actually look at two cases, both in India and the US, which deal with the right to abortion. The first one is Roe versus Wade, which I think around 2 people mentioned it already in the discussion, so I'm assuming most of you are well versed with the case, but I'll quickly take you through what the facts are and what the court actually held. So Roe versus Wade is actually a 1973 case, and it's a lawsuit that famously led to the Supreme Court of the US making a ruling on women's right to abortion. Jane Roe, an unmarried pregnant woman, filed a suit on behalf of herself as well as others to challenge the Texas abortion laws. A Texas doctor also joined this lawsuit, arguing that the state's abortion laws were too vague for doctors to follow, and he had previously been arrested for violating the statute. At the time, abortion was illegal in Texas unless it was done to save the mother's life. It was a crime to get an abortion or to even attempt one. So in this case, the court Blackman wrote the majority opinion for the court. And in the majority opinion, Blackman explained that the court recognized that there was a right to privacy implicit in the 1st, 4th, 5th, 9th, and 14th Amendments of the US Constitution. Additionally, Blackman concluded that privacy rights extended beyond marriage. It included extension to reproduction, contraception, and child rearing decision as determined by other Supreme Court, US Supreme Court rulings. The judge also argued that the Texas laws violated the right to terminate a pregnancy established by the 9th Amendment and the 14th Amendment and ruled the Texas laws as unconstitutional. However, while he explained that women had rights to choose abortions, he also argued that the rights were not absolute. He disagreed with the petitioner's conclusion that the states had no compelling interest in regulating abortion procedures. He in fact said that states may control certain behaviors if they have significant interests to do so. So he explained that the state had significant interest in protecting the health of its citizens, maintaining medical standards, and protecting potential life. Blackman said that the right to privacy extends to abortion. However, this right needs to be balanced with state interests. He concluded that anti-abortion laws that criminalize abortion prior to the 1st trimester violated the due process of the 14th Amendment of the US Constitution. But he explained that during the 1st trimester, the decision to have an abortion remained between the woman and the healthcare providers. However, he noted that after the 1st trimester, the state may regulate abortion so far as the regulations protect maternal health. After the point of viability of the fetus, the state may regulate abortion in order to protect potential life, that is, of the fetus itself, of the baby, if it's post the stage of viability of fetus. The exception to that interest, Blackman explained, was in cases for which pregnant women's lives were endangered. The state has a greater interest in protecting the pregnant woman's lives over potential life, which is of the fetus. And therefore, when pregnancy endangers a pregnant woman's life, abortions must always be legal. So this is what the judgment in Roe versus Wade held. The next case that we're looking at is a relatively recent case in the Indian Supreme Court. This case is Suchita Srivastava and another versus Chandigarh administration. So the facts of this case is that a mentally ill, orphaned woman who had conceived as a result of being, just before I go into the facts, I also want to mention trigger warning because there is mention of rape in this particular fact scenario. So the woman had conceived as a result of being raped by the security guard of the shelter home that she used to stay in. This woman did want to keep the fetus. So the Chandigarh administration filed a writ petition before the Punjab and Haryana High Court in public interest, seeking permission for the medical termination of pregnancy of what they call the mentally retarded girl, describing as suffering from, again, what they say, mild mental retardation. The principal disputes concerned whether her pregnancy should be terminated and who was competent to consent to such termination, whether her own consent was necessary for such a termination, or whether the court could assign the power to consent and exercise its parents' patriae jurisdiction. The Punjab and Haryana High Court noted that mentally retarded parents may encounter difficulty in providing an ideal environment for maximized intellectual growth of their child, especially due to the lack of adequate programs and properly trained teachers, which could teach them to perform the responsibilities of parenting. Therefore, the Punjab and Haryana High Court held that given the mental condition of the victim, the continuation of a pregnancy would constitute a grave injury and may lead to further deterioration in her mental health. The Supreme Court, however, disagreed to the conclusion that the Punjab and Haryana High Court had reached. And they did so on the grounds that she had clearly expressed her willingness to bear the child and that her reproductive choice should be respected. In spite of various factors noted by the Punjab and Haryana High Court, since the Act clearly contemplates that the consent of mentally retarded women is necessary for termination of a pregnancy, the Supreme Court held that a plain reading of Section 3 makes it clear that abortion is permitted only if the specified conditions are met. Since a woman's right to make reproductive choices is a dimension of her personal liberty under Article 21 of the Constitution, the Supreme Court held that it is important to recognize that reproductive choices can be exercised to procreate as well as to abstain from procreating. The crucial consideration being that the woman's right to privacy, dignity, bodily integrity should be respected. And there can't be any restriction whatsoever on the exercise of reproductive choices, such as a woman's right to refuse participation in sexual activity, insist on the use of contraceptive methods, or to carry a pregnancy to its full term, to give birth, and to subsequently raise children. However, the Supreme Court noted, similar to that in the US case, but there's also a compelling state interest in protecting the life of the prospective child. Therefore, the Supreme Court concluded that the termination of a pregnancy is only permissible when the conditions specified in the Act has been fulfilled. The Supreme Court could not agree with the decision of Punjab and Haryana High Court that ordered the termination of a pregnancy in her best interests and exercised parents' patriarchal jurisdiction. To correctly apply the best interest test, the Supreme Court held that the court must undertake a careful inquiry of the medical opinion on the feasibility of pregnancy as well as the social circumstances faced by the pregnant woman, and must be guided by the best interests of pregnant women alone, and not those of other stakeholders such as her guardians or even the society in general. So that's just a brief outline of the two cases. We will now move to the activity that we have designed. Once I read the activity question, again, similarly, we'll divide the group into two. The first, this is the fact scenario for group A. I would suggest you take screenshots for both, just so you know you have both when you're distributed into the groups, because we don't know which group you would be in yet. This is the fact pattern for group A. It states that a new law is introduced in US, which regulates abortion. Following are the key provisions. This law is being challenged in the US Supreme Court as unconstitutional. So the provision states, a pregnancy may be terminated only by a registered mental practitioner where the length of the pregnancy does not exceed 20 weeks. If such a medical practitioner is, or where the length of pregnancy exceeds 20 weeks but does not exceed 24 weeks in case of such category of women as may be prescribed by rules made under this Act, if not less than 2 registered medical practitioners are of the opinion formed in good faith that 1, the continuance of pregnancy would involve a risk to the life of the pregnant woman or of grave injury to her physical or mental health, or 2, there's a substantial risk that if the child were born, it would suffer from a serious physical or mental abnormality. So this group A, would have to decide if this law violates the right to abort under the due process clause of the 14th Amendment. Thank you. Group B has a similar fact pattern, although the provision is slightly different. Again, a new law is introduced in India that regulates abortion, and these are the key provisions. The law is being challenged in the Indian Supreme Court as unconstitutional. So the provision reads as follows. Except as provided, a physician may not knowingly perform or induce an abortion on a pregnant woman if the physician detected a fetal heartbeat for the unborn or failed to perform a test to detect a fetal heartbeat. Notwithstanding any other law, the requirements of this subchapter shall be enforced exclusively through the private civil actions. Any person other than an officer or employee of a state or local governmental entity in this state may bring a civil action. A defendant against whom an action is brought does not have standing to assert the rights of women seeking an abortion as a defense to liability under that section. And group B will have to then decide if the law violates Article 21. Similar to the earlier 2 sessions, we'll divide the participants into Group A and Group B. Group A is, of course, break room number 1. Group B will be break room number 2. We'll give you around 15 minutes to discuss, after which we'll open up for discussions, and 2 representatives can start off by putting forth the viewpoints of the groups. If you have any questions now, please feel free to ask the 2 of us, and maybe then we can divide you into groups.
I think everyone's returned from the breakout rooms. Kalyani, do you want to take it forward?
Thank you. So would group 1, Group A, which is breakout room 1, want to start by putting forth their views?
Aditi, you go ahead and then I'll supplement.
Oh, all right. So for Group A, we had to discuss the given problem from the US constitutional law perspective, and how, on what all grounds would that be held unconstitutional. So starting off, we discussed how there are the precedents, so the rule of stare decisis might come into action. Then we talked about how this law per se is creating abortion as an exception and not as a rule. So what it does when it creates abortion as an exception and not the general rule, or not the general rule, is that it takes away the right to abort, the choice and the autonomy of women under due process under the 14th Amendment. After that, we also discussed about the undue burden standard, which has been developed by the US courts when it comes to determining the contours of abortion. So under the undue burden standard, we discussed various points on how this law is creating certain embargoes on women's right to fulfillment of their fundamental right. So it's creating too much of burden, too much of bureaucratic embargoes on the fulfillment of their right. And we also had this discussion about how asking for opinions of the doctors restrict the choice of the women, because then she has to follow what the doctor is saying. She doesn't have her own choice. So the restrictive nature of the legislation from that angle. And Prithviraj, would you like to add to that?
Yes, just a couple of points. So under the court's present precedents of Roe and Casey and the subsequent offshoots, the second test, apart from the undue burden, will be the pre and post viability test that courts now apply, as they changed the Roe's decisions trimester tests in Casey. So apart from the recognition of 14th Amendment's right to abortion flowing from the due process clause, what the current law states is that pre-viability, that is prior to the 24 weeks period, the state cannot explicitly do a blanket ban on abortion. However, it can show concerns for the fetal development, and it can do so as much as to not pose an undue burden. So it can take measures only up till the line of undue burden. But when it crosses that line and it takes measures, like in this present case, wherein the statute is asking, statute is making, as Aditi said, the abortion an exception and not an abortion a rule. So when you are making this committee, when you are explicitly posing, providing for these conditions that you'll have to prove mental health or physical health effects and the doctor's opinion, and only then you can get an abortion. So this is not only an undue burden, it's a wholesale undue burden of sorts, wherein you are thrashing that right to abortion, which is recognized by Roe and Casey as interpreted in the 14th Amendment. So the courts will struck it down, and also the courts will recognize the chilling effect which this creates, because it makes abortion an exception. However, just a small aside, that the courts, the current composition of courts, conservative judges might I mean, I don't know if they get a majority or not, but they may, hypothetically speaking, go on to do their own interpretation of the 14th Amendment and then say that these tests which we relied on and which the court relied on in the earlier opinions of Roe and Casey were wrong. And that is not what the Constitution in a textualist or an originalist manner provides for. And therefore, there is no such blanket right to abortion, and it might modify these tests. So this is a possibility.
Thank you, Prithviraj and Aditi. So I believe
just a second. Nilavan actually wants to add on to what Prithviraj has said. In fact, he said, in reality, the law might not be held to be unconstitutional after the appointment of Justice Amy Coney Barrett and Justice Kavanaugh by Trump. It is now a conservatives-dominated bench. In September, the Supreme Court declined to block the Texas 6-week abortion law. So just adding on to what Prithviraj has said, Nilavan seems to suggest that the political climate and the composition of the judiciary currently, it could sway either way. Yeah.
Thanks, Meenakshi. Can we now move to maybe group 2 so they can highlight what they think of the provision that was provided to them under the Indian law?
May I?
Yes, of course, Pratibha.
Yeah, so while discussing the problem, firstly, we pointed out the ambiguity which is there in the law. That is, no particular time period as to the tri-semesters has been provided. The complete discretion or sort of criteria is dependent on one factor. So firstly, we highlighted this ambiguity in law. And secondly, the criteria which was given for bringing out the civil wrong, or like the sort of power which was given to any person, was highlighted to show that it's actually infringement of a woman's privacy, because we see that abortion or a choice to procreate or not is a personal matter, and giving the choice to anyone to come and complain against the same is infringement of privacy. We also looked into this problem from perspective of liberty and life, because even though they are directly not infringing or curtailing the liberty of a woman, but by stopping doctors from aborting a fetus, they are indirectly infringing upon her liberty to abort the child. And also, especially in circumstances which involve medical emergencies, which require a woman to abort a child to save her own life. In such situations also, if we go by literal interpretation of these provisions, we see that if a fetus heart is beating, then doctor won't go and abort the child, because in that case he or she has to face a civil action. So in those scenarios, by stopping doctors, they are also infringing upon the right to life of a woman in emergency situations. So because of these reasons, we concluded that this provision is violative of Article 21.
Thank you, Pratibha. Is there anyone else who wants to add to Pratibha's point about why the court would in fact strike down the provision provided to group B under Article 21?
Ma'am, can I?
Yes.
Not that group, but
no, please go ahead.
Yes. Ma'am, so looking at this law from the Indian constitutional perspective, it is sort of an anti-abortion law in its extremity, wherein it goes on to legally recognize bounty hunters, and then it says that the government and the executive arm will not enforce this law. So not only the Pratibha's point that such a law will violate women's right to privacy, but when you provide that anybody who does not have any legal standing whatsoever of my life's choices can come and sue me in court of law. So such a thing will also, our courts will say, is manifestly arbitrary, because the state still has some interest in the protection of that unborn child, but any XYZ private citizen or vigilante groups has nothing whatsoever legal interest in doing so except promoting their ideology. So our courts will strike this down as manifestly arbitrary and unreasonable. And the third clause of the section, which says that a defendant cannot assert her right of seeking an abortion. So what this section does is it throws away all the fundamental right recognized in the Indian judgment that we discussed. So it invalidates that judgment, and it says that the fundamental right read in by the Supreme Court in 21 of decisional autonomy, bodily integrity, etc., will not apply in this statute. So a Supreme Court judgment cannot be undone, which does constitutional interpretation by mere statute. You will have to amend the constitution for that thing. So this statute will also fail foul on that ground, because it takes away that fundamental right which has been read in by the Supreme Court.
Thank you, Prithviraj. I think it's also interesting in both cases to sort of see how the courts would have tried to balance, one, the right to abort that the women have versus the compelling state interest in protecting life of the child, protecting the life of the child or the mother, in fact, to regulate abortion. I know all of us do think that both the laws would most likely be struck down by the courts. Do you think there could be a potential argument which sort of highlights that there is in fact a compelling state interest in keeping these laws as is?
While you're thinking about these points, there are just two comments in the chat that I'd like to highlight. Mihir has added to what Nilavan has said. He said, even though both Barrett and Kavanaugh seem to believe that Texas law was unconstitutional in hearings last week, along with the Chief Justice and the liberals. So, but he feels that, with the Mississippi law case being heard in December, that might challenge Roe versus Wade successfully. Another comment we have is from Ghanavi, who says, one thing I'd like to add is the fetus heart starts beating at of the pregnancy. Some women don't even realize that they're pregnant by this time, which means they're left with little to no time to decide if they want to have the baby before approaching a doctor who's only disincentivized from helping them out. This indirectly infringes upon the decisional autonomy of the womb. And interestingly, I thought while you're also thinking about what Kalyani had raised, is what we had actually done is we had given provisions of the MTP Act before the US Supreme Court in the fact pattern to check the constitutionality of that. And in the Indian case, we had actually given provisions of the recent Texas law that all of you have been discussing. So just a little context.
Just to add to Mihir's and Nilavan's point, so definitely the first December's Dobbs hearing are all eyes by everybody whosoever is interested and follows this issue. But what is more interesting is, except the issue of 14th Amendment and right to privacy and the interpretation of originalism, Justice Amy Coney Barrett, in her confirmation hearings in the Senate committee, when asked, she replied that she does consider Roe v. Wade to be a sort of super precedent. So going beyond the doctrine of stare decisis and judicial discipline in the US legal system, this interesting factor which is to be seen on how justices take it is that, apart from the 14th Amendment issue, how binding a precedent this is, and this is something really new, that it is a super precedent. So it has settled in, and it is so vitally ingrained in the US legal system that it ought not to be overruled by the US Supreme Court, even if there is a legal justification to overrule. So this is one of the interesting factors that is to be seen on 1st December. and I just to give my personal opinion, though it does not have any weight, just my few cents, that I believe the court will not explicitly overrule Roe and Casey, but what it will do, the conservative majority is, it will amend the Casey's test of viability and give it sort of new Dobbs tests. So it will not directly take away the right to abort, but it will counter it in a large manner.
Thank you, Prithviraj, for that. I think if there are any more comments, please feel free to put them in the comment section. While I thank all of you for joining for this session. I would like to thank Tamil Nadu National Law University for joining us as well, for partnering with us. Thank you, Usha, for joining for this session. Before we close, I thought I'll request all of you to please turn on your videos so we can take a screenshot for a picture.
Yeah.
Thank you all. Thank you so much for joining the session. Do you have any questions at this point? Thank you. Then with that, we'll close this session on reproductive rights and personal autonomy, and we will convene again tomorrow at 9 a.m. where we will take you through a summary of all these sessions, and then we will have the on-spot essay competition. I request you all to participate in that. We will meet again tomorrow morning. Thank you. Have a nice day.
Thank you.
Thank you.
I think with that, we can start the summary session. Yeah.
So yesterday we went through 3 distinct sessions. We started with the constitutional founding. In this, we took you through the constitutional stories of India and the US. We took you through how the constitution was enacted, how it came into being. And followed by this, we had a student discussion where we asked 2 questions. The first being a normative question on whether constitutions should be made democratically. And we had a lot of discussion on issues of representation, on having expertise in constitution making bodies, and even the sort of election process in the Indian Constituent Assembly. Followed by, we also discussed some of the processes, in fact, that was adopted in the constitution making process in India. Followed by this, we went into the empirical question on whether the 2 constitutions were actually made democratically. And over here, there was a lot of disagreement and discussion on the 2 processes, both in India and the US. But largely, a lot of the students felt that the Indian constitution making process was fairly more democratic than the US counterpart. Also, the students kept in mind the time and the historical context in which these 2 constitutions were made. Then this was followed by the part 2 of the session where Kalyani took over.
Yeah, thank you. So in the part 2 of the session, we sort of focused on the restriction on curbing the personal liberty of citizens, which is either in accordance to procedure by law, established by law, or through due process. And we saw how the framers of both the Indian Constitution as well as the US Constitution understood what due process was, and if due process was the better doctrine to follow in comparison to procedure established by law. We saw that the Indian Constituent Assembly, many members were in support of using due process of law because they felt that that's probably the best way to ensure personal liberty of citizens. However, we also saw that 2 core members of the drafting committee, Ambedkar himself was not sure whether due process of law was the better doctrine to follow, or it was procedure established by law. He took this sort of a middle path where he said that both have dangers of its own and it's a difficult position to be in, and so he didn't comment on it. While on the other hand, Ladi Krishnaswamy Iyer was against the use of due process of law because he felt that during the United States Supreme Court had not adopted a consistent view of the doctrine of due process, and he thought this sort of a scenario would also happen in India, and wanted to stick to the doctrine of procedure established by law. We then moved to Hamilton's letter, where he criticized this one particular act which disenfranchised a whole class of citizens in America. And in this particular letter as well, he states that most commentators would even read the text by the law of land as due process of law. And he said that disqualification, disenfranchisement, and banishment of a particular sect of people is actually completely against the principle of liberty, and that it could eventually lead to aristocracy or oligarchy. We then had a student activity where we gave the students a scenario. Sorry, just a reminder, it would be great if everybody could mute themselves so that there's no disturbance during the presentation. Right. Then we had a student activity where we gave the students a scenario where there were certain restrictions placed on the citizens of that particular state, and we asked the students to see if Hamilton would advocate or would be okay with such a situation, and would Aladi Krishnaswamy Iyer be okay with such restrictions placed on personal liberty of citizens. Over here, we realized that Hamilton obviously advocated for due process, and so he probably would not have been okay with restrictions on personal liberty of citizens. While Aladi Krishnaswamy Iyer had a different viewpoint, and he obviously did not think that the judiciary should be given the kind of power to decide what due process was, and that as long as the procedure established by law was met, that personal liberty could be curbed. And we saw these very interesting points also come out during the student activity.
Followed by that, we had Dr. Amal Sethi with us to give his remarks on the constitutional founding moments in India and the US. He felt that a point of comparison in both countries should be the fact that both constitutions have endured. And some of the points on endurance that he discussed, at least in the Indian scenario, was some of the factors he felt that contributed to its endurance were, first, the fact that it's very detailed. Then he spoke about the flexible approach that we have in the Indian Constitution to be able, that it's amenable to change. And he also spoke about the sort of party dominance that was, that culture that was there during the first few years post-independence when the Constitution came into being. And then he also spoke about how usually constitutions fail in stressful moments. But somehow in India, we've sort of maneuvered through those stressful moments and were able to hold on to the constitutional structure. And he also discussed the role of institutions and the polity, including corporations, in ensuring or in participating in state building and governance. So this was broadly the first session where we just got an idea of the two constitutions, its sort of history and how it's practiced. And we then moved to the second session on personal liberty and freedom of choice. Over here, we started with just the constitutional provisions, that is the 5th and 14th Amendment in the US context and Article 21 in the Indian context. And then we took students through the sort of history of how due process evolved in the US and how it was then adopted in India as well. So in the US case, we spoke about the three distinct sort of types of litigation where due process was used. The first being the incorporation theory cases, followed by the economic due process cases, and finally the right to privacy cases. And in the Indian context, we sort of saw the evolution from the originalist textual approach that was adopted in Gopalan versus State of Madras, and how that sort of evolved, and slowly we incorporated procedural due process in Khadak Singh and even Satwant Singh for that matter. And then finally, we sort of adopted a substantive due process as well in Maneka Gandhi and cases subsequent to that. And then we spoke about two specific cases and the right to choice, which Kalyani discussed.
Thank you, Meenakshi. So the first case was Loving versus Virginia, which is a 1967 case. It's about the an interracial couple that got married, and they were arrested for having violated the state's ban on interracial marriage. So here the US Supreme Court held that the freedom to marry was one of the most basic civil rights of the man, and it was very fundamental to humans' very existence and survival. And they also cited various other Supreme Court cases to say that you can't deny the freedom to marry a person of another race on an unsupportable basis such as race, although there was an equal application of this on both the white race as well as other races. That wasn't reason enough to curb the freedom to marry whoever you want to. The second case that we looked at was Shafin Jahan versus KM Ashokan, which is a 2018 case, and it's also known as the Love Jihad case. Over here, the case revolves around an interreligious marriage where we have Hadia, who marries a Muslim man and converts to get married to a Muslim man. And we see that her father filed a habeas corpus petition to one, to annul the marriage, and two, to bring her back under his custody. Although the High Court had annulled the marriage as well as brought her back under the father's custody by exercising the parents' patriarch jurisdiction, we saw that the Supreme Court set aside this judgment and declared it as null and void. They restored the marriage of Hadia and Shafin Jahan, and also said that there should be no such interferences between marriage, although there could be probes to check if the conversion was by force. They also said that the right to marry is in fact a fundamental right, and that it couldn't be curbed on such matters. We then had a student activity.
In the student activity, we had actually given them excerpts of a law which criminalized or penalized conversion for the sake of marriage, and they required permission from the state government to convert. So essentially, what we asked the students to do is comment on this particular fact pattern, both as the US Supreme Court and the Indian Supreme Court, based on the two cases that we've gone through and the history of how due process has been used to regulate liberty in both the countries. So here we had students from the US saying that, the US Supreme Court saying that it would be struck down and that it would be unconstitutional because it violates the right to make the decisional autonomy that was sort of upheld in Loving versus Virginia. And even in the Indian context, they did look at Shafin Jahan to hold the same. However, they felt that some students in the Indian context felt that we do have restrictions on liberty, and that if the law was a lot more clear and definite and was not as vague as it was, maybe it could be upheld. Is one of the comments that we got. Yeah.
And we also saw that students felt that if there was a more objective definition of the terms used in the provisions, which did not allow conversion even by way of marriage or by force or other methods, then maybe it could provide clarity and may allow the provision to stand as is. However, the vagueness and the subjectivity that the provision had would actually lead it to be struck down in both the US as well, under both US and the Indian laws. We then had Senior Advocate Jenna Kotari's remarks where she sort of took us through both the Shafin Jahan as well as the Loving versus Virginia cases and gave us sort of this holistic viewpoint as to exactly what the courts debated and how they came to a conclusion. And one interesting point is that she brought in the idea of equality and related that to the freedom of personal liberty and freedom of choice. And we see that even in Loving versus Virginia, the court actually dwells into that, because although they say that, although the lower courts argued that the provisions were in fact okay because they applied equally to each race, the Supreme Court holds that it is still not okay to curb the freedom to marry just on the basis of race.
And that was actually interesting, considering when we do look at personal liberty, we look at it from a very individual perspective, and we don't look at it from a group rights perspective. But bringing in that equality angle actually sort of ties in larger conceptual questions on equality and personal liberty. Then we moved to the third session. So since we were discussing about decisional autonomy and the right to choose in the previous session, we thought we will focus on one particular right, which is reproductive rights. So we started with the sort of legal framework in the US and India on regulating reproduction. Particularly, we were focusing on abortion. So we went through a few state laws in the US which regulate abortion, and we discussed the provisions of the MTPA Act in India, which also regulates abortion here. This was followed by a small discussion on how these two systems in fact look at abortion, and some of the discussions that some of the points that were raised during the discussion were very interesting, where students spoke about the agency of the woman and that being lacking in both jurisdictions. And then they spoke about the decision-making authority being obviously the state in the US, sort of the federal angle as well. And then the third thing that we also discussed was how these regulations are framed itself, and how in the Indian context we don't actually recognize the right to abort, and the MTPA Act sort of is an exception to the larger criminalization of abortion in India. And in the US, maybe the regulations are in fact a sort of exception on the right to abort. So these were the discussions we had. And then Kalyani went through two cases.
Thank you. The first case was Roe versus Wade, which is a 1973 case. This was a case that was brought before the court because abortion was illegal in Texas, unless it was done to save the mother's life. So it was criminal to either get an abortion or even to attempt one. And over here, an unmarried pregnant woman filed a suit on behalf of herself and others. And she was joined by a doctor as well, who stated that the state's abortion laws were too vague. And so here the court held that the right to privacy does in fact extend to abortion. However, the right needs to be balanced with state interest, which is a similar argument that is taken even in the Indian case. And here they sort of divide the pregnancy into various trimesters and then dictate rights based on that. So the judge in that particular case, Blackmun, concluded that, of course, anti-abortion laws that criminalize abortion prior to the first trimester was violative of due process. However, during the trimester, the decision to have an abortion remains with the woman as well as the healthcare providers. After the first trimester, the state may regulate abortion so far as the regulations protect mental health. Then after that, after a point of viability of the fetus, the state may regulate abortion in order to protect potential life. Even over here, if the pregnancy endangers the pregnant woman's life, abortions will always be legal. So they give more interest in protecting the pregnant woman's life over potential life, which is of the fetus of the baby. The second case we looked at was Suchita Srivastava and another versus Chandigarh administration, which is a 2009 case. Over here, the case is of a mentally ill or an orphan child who is carrying who conceived as a result of being raped, and the woman actually wanted to keep the fetus. The Punjab and Haryana High Court also used their parents' patria jurisdiction to sort of say that it was in her best interest to abort the child, and that either the guardians or the parents of the child could in fact give consent to abort the child. And because of the mental health condition of the victim, continuation of a pregnancy would constitute a grave injury and would actually lead to a deterioration in her mental health. The Supreme Court, on the other hand, disagreed with the Punjab and Haryana High Court decision on the grounds that she clearly expressed her willingness to bear the child and that her reproductive choice should also be respected. And they say that so the Supreme Court held that a plain reading of Section 3 of the Act made it clear that an abortion is only permitted if specific conditions are met. And so and since a woman's right to make reproductive choices is a dimension of her own personal liberty under Article 21 of the Constitution, the Supreme Court held that it is important to recognize that reproductive choices can be exercised to procreate as well as to abstain from procreating. So the Supreme Court did not agree with the decision of the lower court and ordered who had ordered the termination of a pregnancy in her best interest. And they held that the court, in fact, should take a careful inquiry of the medical opinion of the feasibility of pregnancy as well as social circumstances faced by pregnant women, and must be guided by the interests of the pregnant woman alone and not any other stakeholders or her guardians or even society in general. And during this decision, they also noted that there's a compelling state interest in protecting the child of the prospective child. So unlike in the US case where they give a higher value to the pregnant mother's life, the court in this case said that the compelling state interest is to protect the life of the prospective child, and that a termination of pregnancy is only allowed when the conditions in the particular act that govern that state have been fulfilled. We then had an activity where we gave two provisions, one that had to be decided in accordance to Indian law, and the second that had to be decided in accordance to the US law, if the provisions would stand would be a violation of personal liberty and choice, freedom of choice. In this discussion, we saw that both groups again came to the conclusion that they could possibly be a violation of personal liberty and personal choice. And we also saw certain arguments raised about how there is this sort of difference in one, the power, I mean, the institution that's actually making the laws, which is this a federal point where in the US, it's the states that make this law, while in India, it's almost a nationalized law. And also we talked about how the woman's choice is also sort of reliant on history, and about how, again, the context and the history of the kind of conditions and the society that we live in has shaped particular laws and viewpoints in India. Meenakshi, do you want to add?
Just to add to that, one interesting thing that came up is because in the fact pattern we gave to Group B, where they were the Indian Supreme Court, private citizens could take action under the Act again for the offense of aborting that in an impermissible manner. And it was interesting to see how students looked at that private action as well, and felt that would definitely be struck down to give private citizens the power to sort of infringe upon the personal liberties of an individual. With that, with the student activity, we closed that session, and we really hope the students did have an engaging time in sort of understanding these concepts, or the concept of liberty itself and the state's power to regulate and curb liberty. So with that in mind, we will introduce the essay competition. So this essay competition, we want students to sort of reflect on the reading material and the discussions we had in answering the essay question. Just the simple rules of it is that you will have to exclusively rely on the material provided, which are the readings, the cases, and the legal provisions discussed. You have about 1 hour. You have to write essay of about 500 to 700 words, and you will submit it on the email ID we will provide in the chat box. So the question is studying US constitutional history and practice useful in understanding contemporary constitutional developments in India? So some of the points we want you to keep in mind while you're doing this is to sort of look back and understand what sort of influence the US Constitution had on the Indian Constitution making process, if at all. And what were the sort of institutions and processes in the American constitutional founding that we adopted, added to, or even left out in the Indian context? And what did we learn from sort of cases and readings on freedom of liberty and personal choice in the discussions, right? With this background, just one thing I want to tell you, please don't plagiarize. We will be doing plagiarism checks once the essays are submitted. And the top 2 essayists from this workshop will be invited for the grand finale in Bangalore on December 11th. And all the best. If you have any questions, please feel free to write to us on the chat box, and we will be happy to answer. We will put out the question as well on the chat box.
Yeah, I'll do that right now. So we will, yes, Hima, you can type the essay. We will send you the email ID that you have to send it to. It will be on the chat box. We will reconvene at 10:30. So please feel free to log off, take a screenshot of the slide if required, or you can stay on the call as well.
I think this is a wonderful program, and I find it extremely useful for the students because one, it was engaging. It was a true workshop rather than just being a nomenclature used as we have seen in a number of other programs. So I congratulate CLPR for meticulously planning and executing the same. And I got the opportunity to reach out to my students, so not everybody, but few of them, and they were happy to share their experience, saying that this was actually enriching their interest in comparative constitutional studies and how to use the comparative methods for the purpose of analyzing, be it fundamental rights or knowing few of the landmark judgments and so on and so forth, and to juxtapose the developments, constitutional developments or jurisprudence between the jurisdictions. I think that was their spontaneous opinion. So I'm glad that this program was planned in such a way, including the the sharing of the reading materials. They have been extremely helping our students, and I think I'm duty bound to place it on records, my sincere appreciation and gratitude for the entire CLPR team. And my special thanks goes to Ms. Usha as well. I think she has been of extreme help and guiding factor, I suppose. And I would be failing in my duty if I don't express my gratitude to Professor Sudhir Krishnaswamy and my own Vice Chancellor, Professor V.S. Elizabeth. She couldn't be here because of a prior engagement, but she has asked me to convey her gratitude to the CLPR as well as the organizing team. And as a faculty in charge or coordinating of this program from TNNLU side, I would like to extend my gratitude to Dr. Amal Sethi and even Ms. Jaina Kothari for their contributions to this program in their absence. So overall, it has come out well. And just this morning, I was listening to the nutshell. I think the summary of what we have done for the last 2 days. Today as well, we are trying to do and learn something and sharpen our skills. So we have come this far, and I was just thinking whether we can plan a few more such programs and include in it the constitutional designing element as well, because you started off with a wonderful discussion session. Is constitutional making democratic? What is the process? So there a lot goes to do with designing also. What are the factors which design the constitutional to be as they are today? Even when it comes to, because there is a differentiation, designing and redesign. So this is something that I was also discussing with my students, I think quite some time back when I was teaching them the comparative constitutional law paper, one of the elective courses that we have had. So overall, it's been a wonderful experience. And I thank everyone, especially the special invitees of set of students who have joined us, I think from School of Law, Christ University, as well as, the SJCL, St. Joseph's College of Law, I suppose, if I'm not wrong. So therefore, thanks to them and all the faculty who have helped us to have them part of this program. And lastly, I would like to say and end this concluding remarks is this is the beginning for our journey to engage with comparative studies, and CLPR has already shared the links, useful links, which can kind of give you exposure, be it literature or the important cases and analysis. So I request all of you to make use of the same and keep in touch. And networking for these constructive activities is also very important. On that note, let me end. Thank you, everyone.
Thank you, Professor. Yeah, and I think it's extremely important that you mentioned that it is in fact the beginning, and this is to create a dialogue of sorts between students and people working in the field of comparative constitutional law. So with that, I think we can just quickly move to the next session, which is just going to be 5 minutes. We just need you to fill a feedback form. And this is extremely essential to us because we need to know what changes we can make to the workshop, the structure, any sort of difficulties you face. It would be great if you could put it down in the feedback. We'll give you 5 minutes to fill in the feedback form. I'm going to just put the link in the chat box. It should be there right now. And any issue at all, please let us know in the feedback form. It's of course not a test. It's just to sort of let us know how much we have been able to communicate through the workshops and what kind of differences or changes we need to make in the next workshop. We will just quickly do this for 5 minutes and then we can close at 10:45. Okay, I think we can continue to the conclusion, closing remarks. And I think you guys can keep filling the feedback form in case you haven't finished it. Please take your time. That shouldn't be an issue at all. But I think it would be great if you could fill it so we actually know how to design our next workshop. So we at CLPR strongly believe that a vibrant constitutional culture is a key to sustaining India's constitutional democracy. And we our work aims at creating public awareness and enabling active public engagement with India's constitutional tradition. So to popularize the Indian Constitution and build a community of constitutionally aware citizens, we designed and produced a t-shirt, the designs on the screen, which contains a beautifully illustrated preamble. And this highlights the Constitution's aspirations, goals, and values, of course. So if any of you are interested in purchasing the shirt, it's available on our website. With that, I'd like to conclude. I thank you all for being a part of this workshop. I understand that it's not easy to be awake and alert on a Sunday morning, but we're very glad to see this active participation, and we also hope that it's been just as fruitful and engaging for you as it has been for us. I would once again like to thank Usha from the US Consulate and Dr. Vishnu Prasad from TNNLU for helping and coordinating with us in making this workshop successful. Thank you all.
Thank you, Meenakshi and Kalyani. It was really, really interesting. You made it so contextual and, so application oriented. And thank you all students. So glad to hear from Dr. Vishnu Prasad that they would like to continue and look forward to. And that's exactly what we were looking for. And, and we look forward to this continuous engagement with the Tamil Nadu National Law University. You're always awesome. We had such a wonderful time last time, and I miss that being physically present there to conduct this workshop. We look forward to your students coming over to Bangalore, and we'll see you in person. Thank you, Kalyani. Thank you, Dr. Vishnu Prasad. Thank you, Vice Chancellor, and thank you all students.
Thank you so much, madam. Thank you.